This is a data privacy detective, but we're going to talk today about May of 2024. Plenty of news in the data privacy space, and we're going to cover Vermont and Illinois and global trends on data privacy today. So a lot to, so stay tuned in. And with us, as always, for this monthly review are Yugo Nagashima and Brion St. Amour. And Brion, you are now senior counsel for the Wabash Marketplace, and that's the digital platform for Wabash National Trailer. Brion, thanks for joining us.
Yeah, happy to be here, Joe.
And Yugo, you are a partner at Frost Brown Todd, a coast-to-coast U.S. law firm, and you focus really on data privacy and cybersecurity matters. And as always, arigato, thank you for joining us.
Arigato to you. Great to be here.
Yugo is one of those rare people who's licensed both in Japan and the United States as an attorney. Well, let's jump right into this. And we're going to start with the state of Vermont, Bernie Sanders territory. Brion?
Yeah, Yugo, it looks like Vermont finally joined the data privacy party with some of the other states. And, you know, what is the applicability of their new act?
So the applicability is a little bit different than what we've seen so far. Of course, you got the usual, the person who conducts business in Vermont and a person who has a product or service that targets a certain number of personal data, right? For example, it's no fewer than 25,000 customers, except for payment transactions. And if you're selling personal data, it's 12,500. And if you make your revenue, more than 25% of your revenue from those sales. The other aspect that's unique here is they have a consumer health data controller. This is really unique here, right? Because we haven't seen much of that. So if you are a person who conducts business that produces products or services targeted to a consumer resident of the state, concerning consumer health data, then you also have a separate obligation, regardless of the other standards that we've seen, right? You don't have to have 25,000 customers information. And by the way, consumer is defined as a resident of Vermont who is not acting in a commercial or employment context.
That's definitely interesting, Yugo. How each of those states kind of break that definition down a little bit, but tell us a little bit about what defines personal data in the Vermont context.
So personal data in general is very similar, and I'm going to talk about personal data and sensitive data together here. Personal data is data that has unique identifiers that is linkable or reasonably linkable to an identifier or identified or an identifiable individual, or to a device that identify or can be linked to an identified or identified individual. So very similar to the other definitions we've seen in other states. It's even very similar to the GDPR. Sensitive data, again, very similar to what you see in California and other states after California, right? Which is social security numbers, government issued identifiers like state ID, driver's licenses, and then you have the usual list, right? Similar to the special categories of personal data under the GDPR, which is race, ethnic origin, sexual orientation, sex life. And this is where it gets a little bit different. Consumer status of the victim of a crime, which we haven't seen before. Financial information, and this one also includes tax returns. Consumer health data, as we know, we talked about it. Personal health data collected or analyzed about consumer health data. So not exactly the information that's provided by the consumer, but the one that received an analysis on it. And Brion, I'm going to say your favorite, biometric data or genetic data, personal data of a minor, and precise geolocation data.
So what are the consumer rights under the statute?
So this is the usual suspects as well, although there's one unique aspect that I'll talk last. The usual suspect is the big five, I should say, in the US, right? The right to access, the right to correct, right to delete, right to data portability, and the right to opt out from sales of personal data, targeted advertising, and profiling. there's a unique one where you have the right to access a list of third parties with whom the controller has disclosed your consumer personal data. This is unique. This is a little bit different. So I think those who have to comply with Vermont needs to watch out for this one.
And then as you kind of look at, the controller's duty or of the data, or even their prohibitions, what are we seeing with this act?
So just in general, big picture, the duties are data minimization, which is basically a data privacy principle, implementation of reasonable administrative, technical, and physical data security measures, what Europe calls technical and organizational measures, and then a mechanism basically for consumer requests and also the consumer to revoke consent. The prohibitions also usual suspects in the United States, which is process personal data for the disclosed purpose, right? The business purpose that you disclose unless you get consent, and also getting consent if you're going to process sensitive data. You can't sell sensitive data, and you can't discriminate or retaliate for a consumer exercising consumer rights. And I just want to go right into the privacy policies because this is kind of part of the duties. And I think this is important for businesses to know. Usually, everyone follows the California model, and we've talked about it ad nauseum. So I'll skip that. But I want to point out a couple of important points here. In the privacy notice for Vermont, you have to list the categories of personal data the controller shares and describe it in detail of what type of entity is receiving it, right, the third party, and how the third party is processing data, which I think some states have, but it's not as detailed as this. And then you also have to identify the company, which I think everyone is doing, but also providing via email or online methods to basically let them do the consumer access requests. Other states have basically said you have to have an online form. Others really don't speak to it. But here it's an email or online methods, although I think online methods are becoming more popular because California requires it. So this is something to think about.
And then, as we kind of look through kind of what does a data processing agreement, or even what do the processors need to do within this approach?
So processors have the usual, which is adhere to the instructions of the controllers, usually written instructions, assist the controller with consumer requests, and also implement technical and organizational measures. The data processing agreement is a little interesting. It's much more specific. I think these are already usually included in most agreements, but you have to have a statement that says the agreement is valid and binding on both parties. You have to describe the purpose and how long it's going to be processed, and the nature and the types of data processed, and the specific rights and obligations of each party's, right to audit, items like that. But I want to get to a very interesting point. Can I talk about it, Brian?
Absolutely.
Yeah, enforcement. So, Brian, we usually see many states have an enforcement mechanism, and that it usually only deals with like one party, right? Which is...
Yeah, I mean, normally it would just be the attorney general, right?
Exactly. So it's a little different here. Attorney general obviously has the right to enforce, and when attorney general does enforce, he has a discretionary ability to basically notice the business and say, hey, you have 60 days to cure. If the violation is, the number of violations are low, size of the complexity of the controller is, if they're not that sophisticated, the violation is, a human error or technical error. But I want to talk about the other one really quickly. Vermont has the private right of action. Of course, please note, it's only against the data broker and a large data holder who violates processing sensitive data and or a consumer who's a minor, or if they're selling sensitive data, because that's one of the prohibitions. So that's something for businesses in Vermont to look out for, or businesses selling a product or providing a service in Vermont to think about.
Well, Yugo, anytime I hear private right of action, I instantly think of California. How does the Vermont Act stack up to California, especially as, someone's trying to comply with all of this patchwork of states?
So Vermont is very consumer friendly, no question about it. The private right of action actually goes into the privacy rights. Of course, it's limited to the sensitive data aspect of it. California, if you remember, it's for data breaches, right? Also, the requirements are very similar in general, right? For example, you're not supposed to sell personal data, no targeted advertising. But you've seen, as I walk through, there are some unique aspects to it, such as consumer rights has this additional third parties. The disclosures for privacy notices also require describing the third parties a little better. So I think we're going forward, if you want to comply with all state laws, you may have to build in some of the Vermont specific items in addition to what people are usually doing, which is following the California rule and making minor edits depending on which states there are. Now they would have to add some Vermont aspects to it.
Very interesting. And with Vermont, Brian, Yugo, we have about a third of the United States now that have adopted relatively comprehensive data privacy codes, correct?
That's right. I think we're at 19.
19, soon we'll be to 20. There are other states, they're going to adopt them this year. So this will probably be the record number of this year. Well, thanks for Vermont. And I'm going to turn now to DataGrail. DataGrail is a company that issues an annual data privacy trends report. And this year's report focuses on DSRs. Now, what are these? Another acronym, isn't that terrible? Data subject requests. That's what we're talking about from these codes. But beyond that, that's where a data subject, that means a person, writes to a company or calls them or whatever and says, look, I want to see my data that you're holding, my personal data, or I want you to delete it, or I want you to stop selling or sharing it, or all the other things one can do. And the number of data subject requests, DSRs, has surged 246% in just 2 years. Now, this is really very dramatic and interesting. So what it means is there's more and more individual awareness of rights that people have, especially with the codes that have come into place in Europe and now a third of the United States. And beyond, people are becoming aware of their right to control their personal information, even if it's held by somebody. So that's the first important point. Now, 40% of these DSRs now are to delete personal information. It's one thing to say, I want to have access to it. Okay, big deal. But it's another to say, I want you to delete it. And the second place is don't sell or share my information. So this is on the upswing in a double, more than 100% way of growth. Now, this was a startling find, I think, in the DataGrail report. They audited, they say, 5,000 websites, and they find that of the organizations they audited, 75%, 3/4 of these companies, still fired 3 or more cookie trackers, despite having requests and not consenting to do the tracking. So you've got 3/4 non-compliance of what's out there promised on a website of businesses. And this shows the laxity of saying, well, we're privacy conscious. We're on your side. Just write us, and actually making it happen. This is interesting. And so on the upswing also, DataGrail reports, is the per year cost of responding to all these data subject requests, deletion requests, access requests. It's about 1% now of total people. Now, that may not sound like a lot, but when websites are, you have 100 million people, you're talking about a lot of DSRs, and it's on the multiple upswing. Finally, a finding they report is 80% of the DSRs come from all over the world, not just the United States for U.S. companies, and from many regions that are not protected by privacy laws, or from states that don't have a comprehensive code. And so what's happening is a kind of general consensus for business businesses that want to have a privacy conscious, sensitive reputation, saying, okay, just contact us if you want to see your information, have it deleted, and so on and so forth. Well, then they better live up to it. And right now, there's a catch up here to be done. Really very, very, very interesting. Now, what do we make of this? Well, privacy awareness is on the upswing, even in areas that don't have a code, that don't have a law backing it up, except the law that businesses should be honest about what they're promising. And finally, this is quite interesting. Many individuals are becoming aware of global privacy control, GPC, as it's becoming known. And this allows individuals to make do not sell requests, do not sell or share requests, delete requests through universal opt-out mechanisms. So they don't have to go to every single company they deal with and say, let me see my data, or let me delete my data. They can do it with a more simple way to opt out through a browser or device. And that avoids the manual opt-outs. Well, you can see why it's on the upswing. Very interesting report. And I wonder, Yugo, what are your thoughts about this?
So it's really interesting to see that you mentioned nearly 2/3 do not really comply. And that's one of the things I deal with constantly, where a lot of companies will have the attorneys, have the vendors come in and set up a privacy policy, but then that's it. They feel that, well, we have these services that are paid and we're done, right? But privacy compliance actually starts once you have the policy in, and once you have the vendor's software set up. Then you have to audit it, you have to test it, you have to make sure it's working. And I think this report, the DataGrail reports, is very important because, again, if you promise something, if you ask an attorney or you ask a vendor to draft out a privacy policy, and once you make the promise, then that's promised, right? And regardless of whether people are coming from other countries or states that don't have privacy laws, now you have a promise that needs to be kept, and right. FTC may look into it. So that's my thought. Brian, what's your thought?
I think in general, anytime I start thinking about enforcement or questions, or you always jump right to the process or procedure, and then think this is a very good case of showing that there can be an important piece of having process and procedures and how you want to follow up, but oftentimes not following one of your written internal processes and procedures can actually put you in a worse position than not having a process or procedure at all.
Be careful of what you say. Well, Brian, let's turn to Illinois. That'll be the third piece today, and we'll finish up. Illinois, of course, first state in the United States to adopt the Illinois Biometric Information Privacy Act. BIPA sounds like a baby burping, but remind us, what is BIPA?
Yeah, so BIPA was, originally a law, enacted back in 2008. It kind of ran under the radar for a long time, and it was really focused all about biometric data from misuse and unauthorized access. And so it requires that companies obtain express consent before collecting, storing, and using biometric identifiers that include things like fingerprints or retinal scan or facial geometry for kind of inward-facing cameras or those types of applications. And, as we look at it, the other thing that's really interesting in Illinois is, like California and now Vermont, it has a private right of action, which is what also makes these a little bit kind of scary from a business enforcement perspective.
Well, yeah. Well, BIPA, for a while, I hadn't heard of BIPA. And all of a sudden, it became a major focal point for litigation. I mean, what happened?
Yeah, so it really, for about a decade, there wasn't much movement at all. And then some plaintiffs' attorneys, began pursuing some class actions, which included really large cumulative penalties in cases against Google, Facebook, or Shutterfly, which really showed that there was a potential for really massive liabilities. And this kind of shifted over time to make it look more like Illinois-based employers and many businesses kind of facing these large penalties for using biometrics, especially in that context of employee time clocks.
So what did the Illinois General Assembly do about this?
Yeah, so a recent bill, SB 2979, was really in response to the Illinois Supreme Court really suggesting to the General Assembly that they need to fix this. And that was in a case, Cawthorn versus White Castle, where they were really urging lawmakers to consider the penalty framework in terms of how the numbers and how you calculate damages. And so this bill is really all about addressing how violations accrue. Previously, each scan or transmission of the biometric data without consent could constitute a separate violation. So if you think about that, every time somebody was clocking in, it potentially created a transaction. And so the new bill really stipulates that only the initial collection of a biometric identifier counts as a violation. So now it's attributing more violation per individual as opposed to multiple violations per individual.
Well, that would drastically decrease the amount at stake in a class action or an individual thing. And so how does that impact businesses, particularly those that use biometrics for employee timekeeping?
Yeah, so as I mentioned, the new bill really is just on the initial collection would be the violation. So this means an employer collecting an employee's fingerprints multiple times a day would only face a single violation, which reduces the financial penalties significantly, which can range up to $5,000 per violation per employee. So here, it dramatically reduces the overall kind of, I guess, scope of damages.
And then I think, didn't they include something including now electronic signatures? What's that about?
They did. And so, it was not really clear under the existing act whether or not you could use digital consents versus a written consent in confirming, compliance with the act. And this really just clears up that kind of aspect of the law, which would allow e-signatures or e-consents in order to comply on that, to obtain that initial consent.
So it sounds like this is the ongoing efforts of legislatures to balance, in this case, biometric privacy, but business concerns of not being sued for millions of dollars over things that might put them out of business. What are the next steps for the bill?
Yeah, so the General Assembly is expected to send the bill to the governor within the next 30 days, and then the governor will have about 60 days to sign it in law, which is what everyone is kind of anticipating here. Interestingly, this is only an amendment on a go-forward basis and is not going to apply retroactively to cases already in litigation, which is causing a little bit of consternation within the business community.
So what should businesses do to stay compliant now with BIPA?
Yeah, and like many of the other privacy laws in the U.S., it's really the businesses need to maintain written and publicly available policies. They need to explain how and why they're using biometric data. They need to outline their retention and destruction guidelines, make sure they're following those retention and destruction guidelines. And then the biggest piece is really obtaining express consent. And that's a kind of hallmark of kind of what we're seeing within American privacy law is that need to get that explicit consent.
It's one of those classic things, I think, of the convenience of biometrics. I can tell you, I just got back from London a couple of weeks ago and went, I'm a member of Global Entry, and you put your fingerprints in, and I don't have any anymore, and all those problems. Well, this time, all they did is you go up to a little thing, and it looks at my face, takes a photo, and say, okay, right through. Off you go. It was terrific. So there's an advantage with biometrics, but then that's that personal data out there, and, what if I hadn't consented to that? That's what you're talking about. And Illinois is struggling with that, and I'm sure other states will as well.
The key is really just realizing what you're signing in some of those.
That's right.
Those terms and conditions.
And I suppose I could write the U.S. government and say, don't share that stuff. Okay, let's see if they comply. We will find out. Well, Yugo, Brion, thanks. We'll be back in July to see what happens in June. And as always, I will remind our listeners, protecting your personal data privacy begins with you.